There's a legal trick police use to get inside your home. No warrant, no probable cause. It's called a knock and talk, and it could cost you everything. Hi, I'm Marc Lopez, former prosecutor, current defender of the people, and we are going to talk about tips to stop cops when they come a knocking. Let's talk about a knock and talk. A knock and talk is an investigative technique where law enforcement officers approach a private residence, knock on the door, and request to speak to the occupants. Now, this practice is typically employed when criminal activity is suspected, but there's not enough evidence to get a search warrant, or the officers say, hey, you know what? Easier than getting a search warrant. Let's go knock on this door and try to get people's consent for us to come inside. What are the objectives of a knock and talk investigation? There's lots of different objectives. Officers will tell you that, well, we are just trying to make sure nothing's going on. But the reality is the officers are trying to gather information, and they're trying to get consent from the occupants of the house for the officers to come inside and conduct a search, and then possibly make an arrest based on what the officers see or find inside the residence. And even when officers are standing outside the door and the door is open and they can see inside, if they can see illegal activity, illegal objects, or things of that nature, they can then enter the premises and say, hey, there's criminal activity afoot. Just like going onto the porch and having the door open, if they can see inside, that's going to give them probable cause. Come inside, they see illegal activity. There's a lot of defense attorneys actually call this knock and enter because so many people ultimately give the police consent to come into the house. And you might be thinking to yourself, well, Mark, I haven't done anything wrong. How can this possibly be legal for an officer to come up to my door, knock on the door, and then basically ask me to come on inside? Well, it's allowed because police, along with members of the public, have an implied license to walk on the areas where I always say where a Girl Scout could walk up to and try to sell you cookies. So if a traveling book salesman and a Girl Scout could walk up on your sidewalk and knock on the door and offer to sell you something, well, an officer can do that as well. So officers are allowed to walk onto the normal path, can be through yards, coming into the side, coming into the back door, where they're allowed to come up on the sidewalk up to your front door and knock on that door. And that's totally allowed. And they're allowed to do what any normal social visitor would do. What they can't do is disable your Ring camera or cover it up or just camp out there and make a nuisance of themselves or start banging on the door, especially if someone says, I'm not home. And even if someone doesn't say, I'm not home, you can't be just camping out there because you wouldn't let a little Girl Scout bang on your door for 45 minutes, demanding you answer your door. So what normal public could do, officers can do as well. And that conduct is given the seal of approval by the United States Supreme Court, cases such as Kentucky v. King and Florida v. Jardines. And it's important to understand the purpose of a knock and talk. No matter what the officer says at the door, no matter anything like that, the purpose of a knock and talk is for the officer to get consent to come inside and get consent to search the actual home. And we have to understand, if you give an officer consent, a lot of defense attorneys, a lot of judges, a lot of courts hold that consent cures all. Consent is a valid exception to the United States Constitution's Fourth Amendment, guarding against unreasonable search and seizures. And the person consents to a search, can't complain about it later. There's some very, very specific circumstances. Just be very careful giving consent. Some would say, such as me, never give consent. Hey, if you really want to come with the warrant. But just understand, the purpose of knock and talk is to get consent from the homeowner or the occupants of the house to come on inside and search the hell out of the house. Now, it's important to note, you are under no legal obligation to open the door for police officers or Girl Scouts or traveling salesmen. You have no obligation to do that. And if they have a warrant or there's some sort of exigent circumstances, that would change. But they're not going to be asking for permission in those circumstances. Also, while an officer is allowed to do that initial approach, knock and talks are ripe for abuse. You know, having multiple officers, is somebody really going to feel free to not give consent to come on inside and search? If officers have their hands on their sidearms, does people really feel free not to say, come on inside? Knock and talks are ripe for abuse of the Fourth Amendment right and privilege against unreasonable search and seizure. And you need to be watching out for this, because if you don't exercise your rights, you might as well not even have them. And I mean that. So let's jump into 7 tips that people can do to protect themselves from police officers that are just knocking on their door. Number 1, it's important to understand the term curtilage. Curtilage is really cool because basically the area surrounding your house is treated as if it's your house. Now, there's still this implied license they can walk on the sidewalk up to your front door. But if you fortify your curtilage, if you put a fence around your area, if you put a chain against the driveway and the sidewalk, well, you're sending a pretty powerful message. Hey, I don't want anybody on here, especially if there's a no trespassing sign, maybe a camera. Hey, that's a pretty clear message. Hey, there's no implied license anymore. I don't want anyone coming up to my door. And courts recognizes Banks versus U.S., United States versus Dunn. Even the Jardines case, we have these cases on here that recognize this curtilage and this powerful legal status of curtilage. And if you make it apparent no one's allowing your curtilage, well, then cops have a less of a right to come do a knock and talk. Now, cops are great at trying to get around this. A prosecutor jump up and down. It's not really a fence. That's just a wire. That's the chain. They still take visitors. The more obvious it is that you don't want people on your curtilage, well, it's also going to be obvious that you don't want people on your front porch knocking on your door. So that's tip number one. If privacy is very important to you, make it very apparent. Not just a no trespassing sign, but a fence, put some chains across your driveway. Now, if you live in a neighborhood like me, you can't really put a fence in the front of your house. At least I can. You can't put a chain against your driveway. So what's some other things that we can do to protect ourselves from knock and talks? Well, let's keep going. Number two, you have an absolute right to remain silent and not open your door for the cops or Girl Scouts, traveling salesmen, Bible salesman, whatever. You don't have to open your door for anyone. Now, if the police have a warrant or exigent circumstance, well, they're going to be able to come into your house regardless. But you do have the right to deny officers admission and refuse to answer questions. Multiple cases for this. Clark State, Hardsburg State. So many great cases talking about you do not have to talk with the police when they're knocking on your door. Again, when they're knocking, they're trying to get consent. Know that so that you can exercise your rights and act accordingly. And if you're thinking, well, if I don't open the door, if I don't talk to them, it's to make me look guilty, your refusal to cooperate or answer questions cannot, on its own, provide reasonable suspicion or probable cause. It's Clark v. State. Someone exercising their rights, you can't use the rights against them. That's not how it works in the United States. Tip number three, knock and talk does not mean knock and camp out. Officers can't just hang out at your front door waiting for you to respond in some capacity. Now, while it's not a United States Supreme Court case, the case of French v. Merrill, officers basically making a nuisance of themselves on the front porch, banging on the door, coming back and forth, making an absolute nuisance of themselves. You wouldn't let that slide. It was a Girl Scout or traveling salesman. You surely don't have to let that slide if it's a police officer, because that's outside the social norms that imply license up to your front porch. Florida v. Jardines explicitly states that police, like any other member of the public, have an implied license to approach your door, knock, wait briefly, not hang out, make a nuisance of themselves. So if that's occurring, try to record that, because that's going to be problems for that officer later. Now, French v. Merrill is not a United States Supreme Court case, but there is a very similar case in Indiana where that's completely inappropriate behavior. And also, this implied license doesn't extend to all hours of the night. We have People v. Frederick, where the officers are coming at 4 or 5:30 in the morning. No. Unless the officers have a reason to believe the homeowner or occupants are up, they can't be coming knocking at weird hours. Now, if there's a party going on, people are coming in. Now, well, guess what? Officers can come at 2:30, 3 in the morning. It's clearly people are up. They can't be knocking on the door at odd hours, because, again, that's outside the social norms that we would expect from a traveling salesperson or a Girl Scout. Tip number 4. Knocking is an inquiry, not a search. Refusing to answer either the door or even verbally does not give the police the right to search your property. And this happened with Florida v. Jardines. They're bringing this drug dog on. Oh, no. You wouldn't expect Girl Scout to bring a drug-sniffing dog onto your property, because that's outside the social norm. So keep that in mind here. And also, police must stick to the normal routes to your house. Can't be coming to the side, coming through your backyard. Can't be cutting across your yard, trying to peek into your window, anything illegal going on there. Now, that's important, because while they are approaching, they are allowed to use against you anything they find in plain view. So, as they're walking to your porch to knock on your door, if they look to their left and they see inside your car something illegal, guess what? It's going to be a problem. If you open your door to tell them, hey, I'm not going to answer your question, you guys had a great day, but then they can see something inside. Perhaps illegal substances, perhaps, who knows? And who knows if they see what actually is what's going on? Maybe they misconstrue something. The government gives officers lots of leeways when it comes to mistakes, because the plain view doctrine gives them lots of power. So be very careful opening your door for police, because you don't know what they are going to perceive inside your home. Number 5, explicitly revoke consent and document interaction. This is why I love cell phones because you can record anything. How awesome. Just record it. So if the cops are knocking on your door and you do not answer, that is a passive way for you to tell them, hey, I don't agree to this encounter and I'm denying you entry. But explicitly revoking the implied consent to be on your property is a more assertive action. And so you can state this through a closed door. Police officers, I do not consent to you being on my property. Please leave immediately. Now, a cutter officer is going to be like, I didn't hear you. Could you open the door and repeat that? Don't fall for that trick. That's the oldest trick in the book. But once you tell an officer you do not want them to be there, there's no misconstruing what happened, especially if you're recording it. I want you off my property. I do not consent to you being here. Pretty cut and dry, right? So once you tell them that, they now no longer have that implied social. Now they can still leave. They can't just jump out or helicopter away. But that's gone. They have to leave. They can't come back maybe the next day or a few hours later. So if you explicitly say, get off my property, I'm revoking consent, you don't got to be a jerk about it either. You can say, just like I said, police officers, I do not consent to you being on my property. Please leave immediately. And that's the language used in the French v. Merrill case, or sort of the language they used. So again, record that because you don't want an officer saying, you were threatening him to get off the property. Oh, no, I was asking you, please leave my property. I'm revoking that implied consent. So you don't have to say anything. That is one way to say that. But then they can say, well, I didn't know if I stayed a little longer than I should. Once you say, get off my property, well, they have to leave. Tip number 6, it's super important to know your state-specific rights regarding knock and talks and warrantless searches. I'm an Indiana attorney. And in Indiana, we have Article 1, Section 11, which is similarly worded to the Fourth Amendment, but it gives Indiana more bang for its and more ways to attack. And so we always want to know, if you're watching this, you want to know what state you're in. You want to find out what your state-specific laws are. Because, again, some states have more protections. Indiana does have more protections than the federal government, which is awesome if you live in this state. So keep that in mind. If this is a topic that you're super interested in, you need to research your state-specific laws on knock and talk and warrantless entry. And I hope you live in a state like Indiana where the laws are more beneficial and better protecting the federal government. Tip number 7, know your rights and potential recourse. So if you feel like you're being abused, your civil rights are being abused by officers at your door or whatnot, hey, try to record it. Because if you don't record it, it's going to be the officer's word against yours. I'm going to tell you right now, most judges and juries tend to believe an officer versus the word of somebody else. But that changes if there's a video or even a recording of what the officers are doing. You want as much evidence as possible if you feel like your rights are being violated. Then you want to talk to an attorney that handles these type cases on a regular basis to try to get you some sort of justice for the violation the officer did upon you. And if people don't stand up to police officers that violate their rights, well, guess what? You're going to continue to violate those rights. Keep that in mind. I love making videos like this because I love giving knowledge to people and letting people know about their rights because I love the United States Constitution. I love America. I love Indiana. And I truly do believe if we don't exercise our rights, if we don't know our rights, well, they're going to evaporate this. So I encourage everybody to educate themselves. And if you have any questions, leave me a comment. I'll try to respond to all comments. Most importantly, remember to always play the fifth.